What's up, everybody? You are not just listening to, but now watching the Bar Bites podcast, the podcast for law students looking to life hack their legal careers by learning from the best and brightest in their fields. Our guest today is Andrew Chivinski. Andrew is a prominent plaintiff's personal injury attorney in the San Diego area, who's known for practicing medical malpractice cases, taking them to verdict, and achieving remarkable success. Notably, he has tried the very last case to verdict that was heard in the city of San Diego before coronavirus shut all of the courts down. So we'll talk with Andrew today about that and some other important cases that he's working on. Andrew currently serves as the board of directors for the Consumer Attorneys of San Diego and has been named a rising star in Super Lawyers magazine. I'd like to give a warm Bar Bites welcome today to Andrew Chivinski. Andrew, thank you so much for being here.
Thanks for asking me to come on. It's an honor. It's my first podcast, so very cool. Very cool.
All right. Well, I'll promise to go a little bit easy on you then if it's your first time. But I'm sure this is a welcome break in the very strange times that we're living in today.
100%.
Yeah.
Welcome.
Andrew, one of the reasons, one of the first things I like to talk about in the podcast to start is just to give you an idea of what the Bar Bites podcast is all about. We are really trying to give law students a glimpse into the many paths that they can take in order to achieve success in the law, or little bites of information into how to become successful members of the California bar. And I think a lot of the students that are listening in or watching here today are primarily interested in hearing about the success that you've had in the field of medical malpractice, a field where lawyers, especially young lawyers, often feel handcuffed by micro legislation that's out there and these medical malpractice caps that we have here in the state of California. So my first question to you is, why medical malpractice law?
Yeah, the answer to that question really comes down to happenstance. I'm a plaintiff's medical malpractice attorney, so I represent victims of medical malpractice. They are the ones who are most affected adversely by the micro legislation that limits what you can really get out of a medical malpractice case, regardless of how catastrophic the injury is. I would not recommend that anyone interested in medical malpractice jump into that field as a plaintiff attorney. The way I did it was I had a friend who started his plaintiff practice and was renting out space at a law office that I was clerking at when I was in law school. I was a file clerk. I was making $15 an hour filing papers after my classes were over at Cal Western. And there was a young lawyer there who had just started his plaintiff practice. He had previously worked at one of the bigger defense law firms in town, Neil Diamont, Frank McFall, Trexler. It's changed names now. I think they've got some new named partners. Anyway, because I knew him, because he had a good reputation there, when I got out of law school and I was looking for a job, he dropped my name and I got a job at one of the premier, if not the premier, medical malpractice defense firms in town. And so I earned a very modest salary, learning about medical malpractice, learning how to take depositions, and ultimately learning how to try cases in the field of medical malpractice. And not only that, meeting everybody in the community who was a player in that arena. So after a decade of that, when I started my plaintiff practice, I was ready to do it despite the limitations, which are not insignificant.
So it seems like you sort of cut your teeth on the defense side and learned medical malpractice law, certainly on the defense side. I really want to take everyone through that journey of how you got there. But just going back for a second, can you give us a little bit of a history into micro, what it is and how it started here in California? And the reason that I ask is that it's foreign to a lot of people in our legal field in general. I started practicing in New Jersey, where we don't have a cap on medical malpractice cases. And I think it's a very interesting topic that a lot of people are not aware of while they're in law school. So can you talk to us a little bit about MICRA? Just what is it and what does it mean for plaintiffs' medical malpractice law?
Yeah, where to start? The best place to start with MICRA is in 1975, which is when this law was passed here at the state level. Governor Jerry Brown was convinced by primarily lobbyists on behalf of the insurance industry that there was a crisis in California, that there were so many medical malpractice lawsuits being filed that all of the good doctors and nurses were leaving town, and that if the governor and the legislature didn't step in to act and prevent these lawsuits, that there would be no good doctors in California, medical care would suffer, and therefore so would the population. And it's probably not surprising to know that the insurance industry, regardless of where it's coming from, has a pretty powerful lobby and are very well funded. And they were able to push through legislation in the 1970s, again, before I was born, that still stands today. Number one, it's pretty much roundly accepted that this crisis that the governor and the legislature was sold on back in the 70s was manufactured. There was no such crisis whatsoever.
Yeah.
All this was an effort by the insurance companies to limit how much they would ever have to pay out on malpractice claims so that they could maximize their profits. Insurance companies bring in premiums from doctors and hospitals and nurses, and they lose money by paying out on malpractice claims. So to the extent they can limit those payouts, they increase their profits.
And what is that limit? I mean, tell our audience a little bit about what those limits are that were enacted back in the 70s and what they are today.
So you might think that they were adjusted for inflation. They were not. In 1975, and I believe it was 75, but it was in the mid-70s, the law passed a cap, a ceiling, a limit on the recovery that anyone can get for general damages, which includes pain, suffering, emotional distress, to $250,000. Now, I would say that really wasn't a lot of money back in the 70s, but it's definitely not a lot of money today, especially when you consider that a child whose obstetrician and labor and delivery nurses fail to recognize that during his or her birth or delivery process that he or she is suffering from asphyxia, and they delay negligently in moving to a C-section to get the baby out. And that baby is born with a brain injury. For the rest of its life, it'll never walk, talk, be able to be independent, earn an income, have a marital relationship, nothing for the rest of its life. In the state of California, the maximum value that baby can get for that lifelong duration of pain, suffering, and emotional distress is $250,000, which probably doesn't even compensate that baby for one day, really, of the damages that have been caused. And so that is what we're dealing with in the state of California. And the byproduct of that isn't just that the insurance companies are limited just to that payout on the general damages. But what happens is that when people with otherwise meritorious cases contact me about potential cases, very often, regardless of whether I think that it's a genuine case of negligence or not, I'm unable to take that case because of the financial limits imposed. And that's where we get into a little bit more about the MICRA legislation. It's not just the $250,000 limit. They also passed legislation limiting the attorney's fees that you can charge. So it's different than any other case. A personal injury lawyer on an auto accident case customarily these days charges anywhere from 40 to 45% of the recovery as a contingency fee, and that's calculated off the gross recovery. Whereas a medical malpractice lawyer is essentially limited to a sliding scale fee that gets lower as the recovery gets higher, and it's calculated off the net fee. So it's after all the costs that you spend on the case are deducted from the recovery. Off that is what you calculate your fee on a sliding scale that's lower and gets lower as the recovery gets bigger. In other words, the effect of the legislation was to discourage lawyers like myself from taking on medical malpractice cases in the first place. And then if we do take them on, it limits what the recovery can be. So it's extremely difficult.
And just so our listeners are aware, I mean, I know that a typical law student knows this, but a typical outsider who does not have a legal background might think of an attorney hearing you talk about the percentage of recovery and everything like that in a normal case. An average person probably doesn't know just how much money it takes to get a medical malpractice case to trial in front of a jury, all of the expert costs that are associated with that. Whereas in a normal case, you might have to hire some experts. A medical malpractice case, you are required to hire doctors as experts. Obviously, the better doctors that you get, the more expensive those doctors are. And you have to prove the standard of care and why the defense doctor may have fallen below that standard of care. We're talking tens of thousands, if not $100,000 or more, just to get that case in front of a jury. Is that kind of what your experience is, Andrew?
If you're 100%, if you're doing it the right way, if you're really putting your time and effort and resources into your client's case, in a medical malpractice case, you're spending anywhere from $75,000 to $200,000 out of your own pocket to fund the litigation. If it's a birth injury case, the experts that you have to hire an obstetrician expert, a labor and delivery nurse expert, an economist to testify about future economic damages, a life care planner to talk about the care needs, a pediatric neurologist to talk about the effects of the brain injury on the child. Then you've got to take all the depositions of the treating providers involved in the care. That's $3,000 a pop when you factor in the court reporter and videographer costs and transcript costs for each of those depositions. And so it's a significant financial investment. And if you're looking at cases that have a $250,000 maximum value and your costs, not just your fee, but your costs are going to be half of that, it begs the question, what's the point? Even if you win, the financial benefit to the client, let alone yourself as the lawyer, but to the client after the costs and fees are deducted is nominal. But the risk of losing everything is very real.
Yeah. And again, we're talking non-economic damages when we talk about this cap, right, for $250,000. So if we're just talking about the non-economic damages, which are pain and suffering, which if you have any experience in this field at all, you know that these medical malpractice cases, when a doctor messes up, usually the consequences of that are so much higher than in a typical case where if someone simply has some negligence associated with their acts. We're talking about $250,000 in recovery for non-economic damages. You are investing at least $100,000 into that case. Your attorney's fees are lowered. The recovery to the client is less. I mean, you don't have to be a math major to realize that you're betting the house on something that has a very limited recovery for both you and your client. It makes it extremely, extremely difficult to want to try these cases or to do that. So I guess, that sort of leads us into our next point here, Andrew. You kind of have to be a person who's willing to stand up for the little guy if you're going to get involved in this area of law. What is there something from your background or something that you point to that you can tell us about where you feel like you're doing noble work here in trying these cases and accepting these type of clients?
I'm trying to think of a brief way to answer that question, because it definitely didn't start like that. My career started like most law careers do. I needed a job, and I wanted a job that would pay my bills, which included student loan payments, but that it would also afford me the opportunity to get experience and to advance. And in my mind, I always thought that I would end up being a partner at that big law firm that I was working with. And I was almost there. I was working as the right-hand man to the number 2 guy in the firm, somebody who in this town is basically a living legend. And I was his number 1 guy. I had an office on the top floor, beautiful view. I was trying my own cases. I was on that path. But I think after a certain amount of time, I kept on hearing from the plaintiff lawyers that I was up against that, oh, you're going to be a plaintiff lawyer one day. One of these days, you're going to see the light. You're going to be a plaintiff lawyer. And I still don't know why that was, or what they saw in me, or what there is in me. But for sure, I think people that are drawn toward this practice as a plaintiff lawyer, there's definitely a sense of wanting to do something for someone that doesn't have the powers that be behind them. I mean, when I represented a doctor, he or she was a doctor. They had the power of their medical career and their education and training and experience behind them. Plus, we were funded by their malpractice insurance company. I mean, I wasn't spending money out of my own pocket to defend these doctors. I would just, I would get a bill from an expert, and I would send it along to the insurance company, and they would pay it. We were very well funded. Whether I was a good defense lawyer or not, it didn't matter whether I was there or not. If I left, another very good defense lawyer could be easily put in my place with a well-funded insurance company to do the same job that I was doing. On the other hand, with plaintiffs, victims of medical malpractice or elder abuse or even personal injury, they need good lawyers who know how to win, who are able to fund their cases and keep pace economically with those insurance companies, just in order to give them a shot. But more importantly, they need somebody who can be their advocate. And I really couldn't tell you what other people saw in me, but I heard probably 50 times from a variety of different people that I was going to be a plaintiff lawyer one day. And sure enough, I was. I don't know what it was that led me to that. But I'm glad I did. It's made the difference in my whole life, really.
Well, talk to us. Let's see if we can dive deep. I'll play the role of psychologist for a second, but talk to us a little bit about your childhood. I know that you're from the East Coast originally, right? You're from Pottsville, Pennsylvania. Is that right?
That's right. Yeah. If there are any beer drinking aficionados listening to the podcast,
plenty.
I was going to say, if this is a law school podcast, I'm guessing there's a lot.
We've got a bar on campus here at USD. So yeah.
That kind of school. The oldest brewery in America is located in Pottsville, Pennsylvania. Yuengling is my hometown. That's where I grew up. It's very rural. My dad was he was a general contractor. He had his own construction business, and he made me and my 2 younger brothers wake up every morning in the summers at 6:30 in the morning and go work on the construction sites with him. And the idea was that we would hate it so much that we would want to go get an office, an easy, office job where we weren't busting our hands and legs up every day. And I guess it worked, although sometimes I'd rather be out, hammering nails in the sun than
Sure.
In the office, depending on what I'm doing. But that's how I grew up. No lawyers in the family, no influence to be a lawyer, really to speak of.
Are you the oldest? Are you the oldest of your all of your siblings? I know you mentioned you have two younger brothers, but does that make you the oldest, or are there any more?
I have an older sister who lives in Portland, Oregon.
And as the oldest son, I guess, did you, was that idea of protecting your younger brothers instilled upon you by your parents, or what kind of older brother were you, or were you the type, I've got an older sister too, who would torment me, but if anyone else tormented me, she would be the first to step in, that type of relationship. What kind of relationship did you have with your brothers?
I would say it's more along the lines of the latter. I was not a very good older brother. I was not. I love my little brothers, but I tormented the heck out of them. And it wasn't until much later in my career or my life that I realized that and made amends for that. But yeah, I definitely wasn't a protector or a lead by example kind of person. I just wanted to do my own thing more than anything.
And you said that you were the first lawyer in your family. What did your parents think when you told them that you wanted to be a lawyer or that you were going to law school?
Probably the same that a lot of parents think when their kids tell them something like that. It's a noble profession. By and large, it has that reputation. It involves higher education, which is always something parents think they want to see their children do. And so I had nothing but support from my family in chasing that down. None of us knew what it meant, including myself. What it meant to go to law school and then to be a lawyer and what all of that entailed in terms of the finances and the commitment and what it really looked like when you did become a lawyer. I had no clue. No clue.
And you mentioned that you went to Cal West to attend law school, right?
That's right. Yep.
What went into your decision to go to law school at Cal Western, and what attracted you to that school in particular?
So I went to a college in Philadelphia, right in the city, and really loved being in the city. I applied to two other law schools in the city: Temple University, Widener University.
Oh, my father went there.
Well, there you go. Yeah, great school. A lot of friends of mine went there. And the other, I applied to Thomas Jefferson and Cal Western in San Diego. And the reason for that was I had never really been anywhere. I'd been in the East Coast, specifically the Northeast Coast in Pennsylvania my whole life. I had never done the backpacking across Europe thing. I'd never really traveled. I'd never been anywhere. And I figured if I go to law school, I'm more likely than not, I'm going to be there for a while, wherever I go. And so I applied to some schools in Philly that I thought I'd like to go to. And then I thought, okay, what's the exact opposite from the Northeast? And that's the Southwest. So I applied to two schools at the most Southwest spot. I got into both. Cal Western offered me a little bit of a scholarship. The school I wanted to go to most was Temple, and they waitlisted me. And I had to accept my scholarship to Cal Western before I would know whether I got past the wait list at Temple. And so I had to make the decision, and I made it. I had never visited Cal Western or San Diego until I moved out here to start attending classes. I just knew of the reputation of San Diego, which was enough for me, like I'm sure it is for most people.
Yeah, I actually went through the same sort of process. I had never visited San Diego before I moved out here, but it's one of those places that it either sucks you in right away. I knew day one that this was my new home, or, it's not for everyone else. But Cal West in particular is an interesting school for me. I don't know too much about the school other than my exposure to it through the mock trial program. I coach one of the mock trial teams here at USD, and Cal West time and time again has mock trial teams in the finals of these tournaments that I coach in. And I'm wondering, were there any classes in particular that you took at Cal West or programs that you were a part of that had an influence over you in your legal career?
I know probably you want me to say yes and give you an example.
No, I just want you to be honest. Tell me whatever, however it happened,
The reality is that I think I got a very good education at Cal Western. I think I got very good bar study preparation at Cal Western. Um, but I was not someone who got really wrapped up in the school and the school's programs. I did not do mock trial. I never did a mock trial while I was in law school. What I did was I worked as a clerk at various local law firms here in town. And that, I think, if anything, made the difference for me or put me in a position to succeed, it was that.
How so?
When I graduated law school, I was on a first name basis with a lot of lawyers who were names in town. And I knew, I could go to a law firm or to an interview at a law firm, and some people would ask me about my background, and I would know the same people that the attorney who was interviewing me knew as a law student, somebody who's never practiced a day. And I think just that alone put me in a position to get a really good job at a really good law firm. But not only that, to just kind of get a sense, I felt like by the time I started working as an associate lawyer at a law firm, I felt like I was already a 2 or 3 year lawyer, just because I had been working in law firms. I knew the lingo. I knew how civil litigation cases worked. I knew the names of other lawyers. I knew who the big law firms were. I knew all these things that a lot of people who come out of law school and spent their whole time just at the school didn't know anything about. And so I felt like I was able to hit the ground running. And at the end of the day, when you go to work at a law firm, the lawyers that hire you, they're looking for somebody to dump work on, and they don't want to have to worry about it. They're busy. They just want to be doing the high level stuff that they should be doing at that level of their careers. They want a lawyer who they don't have to explain everything to and hold their hand and look and review everything. And if you can be the person that they have to give minimal supervision to, you're super valuable. Super valuable.
I think that's fantastic advice. I often tell students something similar, that it takes someone who is a real self-starter to be a successful attorney, whether you're trying to work your way up at a large law firm or whether you are opening up your own solo practice and you just need to figure out how to get something done. Having that mentality is very, very important. But I also think it's very important to be able to bounce some things off of a mentor. So what I'll ask you next is, did you have any sort of mentor when you were either clerking at law firms while still a student or in your first job outside of law school that really had an influence over you in your life?
Yeah, I definitely did. I had at least 2 while I was in law school, and these were lawyers that I worked with they're still lawyers today. One of them, in fact, I tried a case against as a defense lawyer, and he beat me. But I was a law clerk for a very long time, and we still go out to lunch. And then at the law firm that I started with, I was fortunate in that it is well regarded as probably the best medical malpractice defense law firm in town. The people that are at that firm that are named partners are literally living legends in town. They've been around since the 70s in this and in this town, and they really shared a lot with me and taught me how to conduct myself. And so having people to watch just how they talked, just how they acted in court, at depositions. I mean, I just parroted everything. Everything I do is a combination of something I've seen people who I think are very smart do. And I continue to pick up on stuff. I'll catch myself at a deposition asking questions that I saw another lawyer who I think very highly of ask, and asking them in the way that he or she asked the questions. And so without a doubt, that's having those mentors is important. For me, it was luck. because I was just looking for jobs to help with bills while I was in law school.
Right.
So I was lucky that I was able to work with some people that I learned from. You can learn the wrong thing to do, and you can learn the wrong way to act, especially if you go out and intern or take a job with a plaintiff firm. I'm a plaintiff lawyer, so I'm not trying to speak badly about the other lawyers in my profession, but there's a lot of people who hang shingles and start practices, and they're really just trying to make money off PI cases, and maybe they don't know how to take depositions or try cases. They definitely don't know how to teach young lawyers how to do it the right way. And so if you go there as a young lawyer, you're not going to get those same experiences, and you're not going to get those same educational opportunities to learn from somebody who knows what they're doing and who cares enough about what they're doing to teach you how to do it the
Sure.
right way.
Sure. I think that one of the challenges that a lot of law students in particular are facing right now is obviously we're in the middle of a worldwide pandemic, and going out and gaining that experience that I think is so integral to the practice of law that you're describing. A lot of those opportunities are now different, right? Getting those jobs is a lot different than it used to be, or non-existent in a lot of situations. I know I've spoken to a number of students who had jobs lined up at very prominent law firms and had jobs lined up for the summer that fell by the wayside because of this pandemic. Do you have any advice for students now who are in law school who are hoping to gain that type of experience, but might not have an opportunity to go clerk at those firms, or right now to go sit in on a jury trial and watch how Andrew Chivinski tries a medical malpractice case? What would you do if you were in law school today, and what would you say to those students?
I would say, and this was prefaced by the fact that since this is a one-of-a-kind situation, none of us have dealt with this before, nobody knows really what the tried and true methods are for law students in this generation. These students are facing something that I sure as heck didn't face. I can't think of anybody who faced what they're facing. And so all I can tell you is what I think might work. And what I think might work is the same thing that worked for me in the past times 10. And what I mean by that is it's just going to take a little bit more effort to get those opportunities and to capitalize on them than it otherwise would have. They're still out there. Yeah, there's no jury trials happening this year, probably not until next year. So, okay, fine, cross that off your list. You're in law school anyway. You don't have to necessarily worry about being an expert on how to try a case. You've got a long way to go before anybody is going to expect you to be able to do that at a high level. So don't worry about that. What you should worry about is getting to know good people, getting those good people to have a high opinion of you and your work product, and putting yourself in front of them and their peers so that you get opportunities, whether it's a volunteer, an internship, a paid internship, whatever. You just want to get those opportunities so that when things open up again and business is booming on both sides of the aisle, they know who you are. They've seen your work product, and you're at the top of the list of that large stack of resumes they're going to get if and when there's a job opening. And so there are things you can do. The Consumer Attorneys of San Diego have law school memberships. So law students can have a membership to a plaintiff attorney organization where you get access to a lot of the programs that we have, the educational programs. I think, I don't want to speak for sure, but I think you've got access to the email listserv, which is a pretty big deal. And by being a part of that, you can go to the events, you can attend the Zoom meetings, you can email on the listserv, you can find out who's who. We've got mentorship programs that you can go be a part of, and you show up.
I think that's great advice.
90% of life is just showing up, and thank God for that, because that's a lot of what it takes, really. That's what I've done, is just to show up and be there, because not everybody does. And so, especially now. So I think to answer your question, it's the same formula, but it's even more. Just put more effort into it than you otherwise would.
Yeah, I think it's great advice. I know CASD obviously has a number of programs, both for active trial attorneys or litigators and for law students. I know the mentorship program is one of the things that I'll say you do. I know that you're a member of the board for CASD, so they really have a number of fantastic programs. I also think that a lot of law firms right now are still offering job opportunities. It's just a little bit different than it used to be, right? My law firm in particular, we held all of our meetings on Zoom like a lot of businesses are doing right now. And there's still an opportunity to learn from attorneys and to have those same experiences that you would have otherwise, except it's just you have to be adaptable. And I think that's a really important quality to have now, whether you're a law student or whether you're going to try cases. So that's really great advice, Andrew. Take us back now to, you mentioned that you worked at Neil Diamond, that was sort of your introduction to the area of law that you now practice. Can you tell us a little bit about what was it like working at that firm, and what in particular did you learn there that kind of led you in your head to think, okay, now is the right time for me to branch off and to open up my own law firm? I assume you opened up your own law firm straight from Neil Diamond, or was there something in between?
There was something in between that played into the decision significantly that I can talk about. And so, at Neil Diamond, I was there for about 8 years. Like I said, when I started working there, because I had clerked kind of in that field before, and I was familiar with civil litigation, I was just a little bit ahead of the curve than some other associates. And I very quickly was able to distinguish myself and got opportunities to work for bigger partners and bigger partners and bigger partners until I was working for the biggest partner in the firm. And what I learned there was, I guess, two things really. Number one, how to conduct yourself. This is a contentious business. You're literally in conflict with opposing counsel on multiple cases every day. You're going to come across people who are jerks, or we're going to treat you like a jerk. They're going to put you in tough spots. You're going to be forced to deal with them, talk to them. You're going to be forced to conduct yourself in front of a judge in a courtroom, maybe in front of a jury one day, with all those pressures added to it. And so just watching some of these lawyers who had been doing it forever, to the point where they just were, no matter what the circumstances were, they were just cool as a cucumber. I don't always do it justice. I lose my cool sometimes. I oftentimes will send an email that the next day I wish I would have waited 24 hours to send the email. But I would like to think that at least more than 75% of the time, I conduct myself appropriate. I carry myself with dignity and integrity. And that's something that I learned at that law firm, directly and indirectly, just by watching some of those lawyers conduct themselves. And the other thing was just how to do what good lawyers are able to do in order to win cases. And that's taking depositions, working up your experts, and then ultimately trying the case. When you go to work at a big firm, you're going to start doing stuff that's pretty menial: discovery responses, motions to compel discovery responses, summarizing medical records. It's not glamorous. You have to learn to do it. You gotta cut your teeth doing that stuff, but you want to ultimately get past it and to be in a position where good lawyers are teaching you how to take depositions. Because at the end of the day, you might be really good at reading medical records and understanding what's in there, but if you don't know how to depose a doctor in a way that gets good testimony that you can use at trial to win your case, you're nowhere. you're just nowhere, especially as a plaintiff lawyer. And so I got the opportunity to do that at Neil Diamond, and then ultimately they let me try cases by myself. I second chaired cases with several different lawyers there too, but I ultimately was trying cases on my own, and I was at a pretty high level. And I'll just jump into the second part of the question. I left the firm not to start my own plaintiff practice, but and here's the truth. The firms that offer you the most opportunity and the most experience oftentimes do not pay what you thought you were going to earn as a lawyer when you applied for law school. I don't know about you or anyone listening to this podcast, but I know that when I applied to law school, I thought when I graduated, I'd have a six-figure job waiting for me, and I didn't. Probably not until 7 years into practicing was I earning a six-figure salary. And at that point, it was just barely a six-figure salary. And that's a long time to go with student loans. And,
Sure.
I'm living in San Diego. And so I had an opportunity to go to work for a bigger firm that offered a hefty salary. And I took it. I thought that this was a point in time in my career that I needed to make that financial jump. And I wanted to make more money. I wasn't getting ahead financially. And so I took that job and I went to work at a bigger firm where the lawyers I worked with, for the most part, were not people who I wanted to emulate, with the exception of one person who's still a good friend of mine today. There were no good mentors there. The cases I was working on were not cases where I was getting any kind of genuine sense of worth out of it. I, for the most part, wasn't even taking that many depositions. I sure as heck wasn't getting an opportunity to try cases. And ultimately, I ended up working on a trial team that defended nursing homes in nursing, neglect and elder abuse cases. And ironically, the team leader that I had for those cases was, if I was going to emulate anybody at that firm, it would have been him. His name's Mike West. I don't feel bad giving him a shout out. But the cases that we were working on, they were awful. They were just sad, horrible cases. And the things that I felt the clients we represented, again, the insurance companies defending these nursing homes, wanted us to do in order to avoid turning things over, it really made me not want to be a defense lawyer anymore. Let me put it that way. And that was kind of this. I just completely lost my interest, and I no longer wanted to be a lawyer in that industry anymore. And I wasn't a good associate. I wasn't being a very good person. And so it was time for me to make a change, and I was able to do that.
And how did you do that? I mean, I know that a lot of people go into this profession with the ideal that at the end of the day, you can be your own boss, you can hang your own shingle, and you can start your own law firm. But what most people are not aware of is obviously the amount of work and effort it takes in order to have a successful law firm and to run it successfully. But also, I think a lot of young attorneys struggle with that notion of, how do I know I'm ready? And so for you, coming from the defense side at Neil Diamond and going to that second defense firm that you just described, that I guess you don't want to name for fear of talking badly about them. But how did you know you were ready to go out and hang your own shingle?
At that point, I had been practicing for a decade. I had 3 solo jury trials under my belt. I had at least 5, maybe 6 second chair jury trials under my belt, hundreds of depositions. There was no doubt in my mind, you could give me any case, and as long as I could fund it, I could manage it. And so the 2 things I didn't have were the money to fund those cases, and where was I going to get the cases from? This isn't something that I had spent years developing. It wasn't like I was went about being a defense lawyer with the idea that one day I would become a plaintiff lawyer. It literally happened, almost overnight. What I learned was when I became a plaintiff lawyer, I joined the Consumer Attorneys of San Diego. There's a really good guy in that organization who was I believe he was the incoming president at the time. He's a past president now, Brett Schreiber at Thorsness Bartolotta. He welcomed me in, put out an email to the whole organization saying that, hey, Andrew Chivinski is a plaintiff lawyer now. Before I knew it, I was getting more emails than I could respond to.
Oh, wow.
For contract work, not cases.
Right.
But hey, I need somebody. I'm busy. I need somebody to oppose a demur, to oppose a summary judgment, or to help me out with discovery responses. Can I pay you $30 an hour? I think the most I made was $65 an hour. One lawyer paid me to do, whatever. And at first, it was I kind of felt like a defense lawyer all over again, in that I was an associate doing the grunt work, but I was a free agent. I was working for, multiple different top tier lawyers in town doing all sorts of different things. And it put me right back in the spot where I had an opportunity to put my work product in front of these lawyers who were good lawyers. And before long, they were so excited to have somebody who knew what they were doing work for them, that they would get a case and that they weren't going to take because it wasn't big enough money, or they were just too busy, and they'd refer it to me. And little by little, in between the contract work that I did and the small level cases that I was able to take on and resolve, I was able to build my practice. And, at first, if I got a case referred to me that I knew potentially was going to be expensive, I would call up somebody that I thought might be interested in co-trying the case with me. And the deal was, hey, look, I brought the case. I'll do all the work. You fund it. We split the fee. So I would ultimately take less of a fee at the end of the day because the other attorney was funding the whole thing because I couldn't. But once you start to get those settlements in and you start to earn some fees, you build up your war chest a little bit. And then all of a sudden you're taking cases on your own. You can fund those cases and you're not doing contract work anymore. And so that's how it went for me. I'm extremely grateful to Consumer Attorneys of San Diego, because without that organization, I never would have been able to make the leap. And so that's why I serve on the board of directors, is because I feel an obligation to that organization to give back, because really I would not be here if it weren't for them.
Yeah, sometimes all it takes is one chance. And Brett is a guy who I would love to have on the podcast. I've heard so many good things about him. I've obviously seen him on webinars, and he has worked closely, as co-counsel on some cases with some guys in my building. But that's fantastic that he was able to do that for you and kind of go out on a limb for you like that, because there are so many young attorneys who ultimately try to go into the profession. They're probably fantastic attorneys and could make it otherwise, and don't get that opportunity or don't figure out a way to make it work for themselves, and then have to, go take a paying job again as low man on the totem pole somewhere. So it's fantastic that you've been able to make it work, Andrew. Obviously, you have achieved a level of success now where you are not just taking those cases that some lawyers don't want. You're taking your own cases, and you're able to screen out cases and try some of the most important cases in your field. Was there a time in particular or a case in particular that you want to talk to us about where you kind of had that moment of clarity where you're like, you know what, I've sort of turned the corner now, and I'm not just taking, $15,000 auto accident cases? Was there a case that you can point to and look back on and say, this might be it for me?
Yeah, there's one case that actually did it. There was a case, an older gentleman worked. He lives out in Arizona with his wife. They raise goats. And what they do is they would come into the San Diego for the Del Mar Fair every year. And I don't know, a lot of people just go for the turkey drumsticks and the roller coasters, but there's actually livestock competitions there where people from all over the Southwest bring, goats, cows, and they show the livestock, and they get it's like a blue ribbon thing. It's just
Sure.
This gentleman they stay in trailers, and this gentleman was woken up early in the morning by some other livestock company that was packing up their stuff and leaving. They were making a whole bunch of noise, and he gets out of his trailer and goes off and tells them to pipe down, kind of your classic grumpy old guy situation. And some young guy who was the son of the owner of this other company punched him in the face and knocked him down, and he busted his hip and broke it and had to go to the hospital and get a hip replacement. And so somehow that case that's so funny. Now that I remember it, they were referred to Neil Diamond, the defense law firm that I had worked at. And they roundtabled it. And like a lot of lawyers, they said, well, that's an intentional tort. He intentionally punched him and hurt him. Intentional torts are not covered by insurance. And so there's where are we going to get them? Where are we going to recover any money from? And financially, it doesn't make sense for us to take the case as a big firm. So let's refer it out. And they knew that I had just started my plaintiff practice, and so they referred it to me. What I can't believe they didn't think about, and what I did, was that you can allege negligence. What I did was I looked into the facts a little bit, and I realized that what had happened is the young guy thought that my client was threatening his dad, who was the owner of the company. And so he thought when he threw the punch that he was protecting his dad. So I alleged negligence, that it was a negligent defense of others situation. And by alleging negligence, and I took one deposition, I was able to get a settlement. I think it's confidential, but at that point in time, I was scraping by. I could barely afford the fee for the mediator that mediated the case. I think I had to come up with like $3,000 for a mediation. And we got there and we settled the case for a pretty significant amount of money. And all of a sudden I had over $100,000 in my bank account.
Wow.
And it was, that used to be what I would make in a year at like little, paycheck increments. And
Right.
So that changed everything for me. You just carry yourself different when you're working up cases, when you're not worried about whether or not you can pay to do things. And then you can be more aggressive and you get better settlements and better outcomes. And that's 100% what happened to me.
Wow, it's a great story. It's one that I hear every so often, where especially when you're first starting out, you are referred cases a lot of the time because other lawyers either think just from the facts that they see on an intake sheet that they didn't take, that some paralegal or associate took at their firm, they'll be presented with the facts of a case and they'll say, I don't think it's worth it, or they'll hear about the facts of the case and do something like the firm did in your case, where, it's an intentional tort, probably not going to be a big case. Let's refer this out. It's so important for any attorney, especially a young attorney who's starting out, to always consider, is there an angle that someone who has sent this to me has not already looked at? Because every so often you will find that diamond in the rough that could ultimately change your life, and certainly sounds like it did for you in your young practice. So that's fantastic, and that's just good, diligent vetting on your part. From that moment to get to where you are now, there's obviously been a number of success stories along the way. I'm sure there have been some stories that were not as successful as well. Anything that you want to share with us in terms of recent successes or learning experiences that you've gone through?
Yeah. And let's not make it all rosy. You mentioned the last trial that I had, I think, and I think because the judge that I tried this case in front of said this recently. He was on the bench trial webinar, Judge Taylor in Department 72, probably one of the toughest judges I've ever and will ever be in front of. But for some reason, my favorite judge, because he's really smart and he just forces you to be a better lawyer. Anyway, I tried a case in front of him in late February. Then, of course, March comes around and the court's shut down and COVID comes. I'm pretty sure it was the last case that was ever tried in San Diego to a jury. And
let's hope you don't hold that title forever.
well, I mean, I hope so too. But I think the reality is that in the absence of a safe vaccine and or treatment, whenever they do start jury trials again, it's not going to look like it did when I tried that case. It's going to be different. How they go about getting juries, everything. It's just going to be different. That case was a case that I put my heart and soul into. I spent 2 years working it up. I videotaped every deposition. I knew we were going to try the case, and so I took every deposition, knowing full well that I was going to be using the video testimony at trial. So I asked my questions that way. For the most part, everything went right. The testimony came out great. My client did really well. Her family was there every day. They were awesome.
Can you give us a little bit of the factual background of the case just to give us some sort of context about it, or is it all?
Sure. No. Yeah, I represented a middle-aged woman who had 2 children and wanted to. She didn't want to have. Her and her husband did not want to have children anymore. At the time, they were offering, and this was back in 2010. They were offering an alternative to tubal ligation in the form of a device called Essure, ESSURE. It's, you no longer can get it. Bayer manufactured this device. They no longer sell it domestically because.
And what is that tubal ligation? Can you tell us what that is?
Tubal ligation is getting your tubes tied.
Oh, okay.
That's just the medical terminology for getting your tubes tied. That's how normally, and to this day, if you're a female and you want to no longer have children, you can get your tubes tied.
Okay.
Men have a vasectomy, women get a tubal ligation. Essure was an alternative to both of those, where they would take a little a coil. It was a coiled up, I want to call it metal, but if you were to touch it, it wouldn't really feel like metal. It's almost like the material you would have in a stent. It's in the body, but it's coiled. And a doctor, in this case, an obstetrician and gynecologist, would laparoscopically place the coil into your fallopian tubes. And what would happen is, because of the coil design of the device itself, it would cause an inflammatory response and block up the tubes so that eggs wouldn't get through and you wouldn't get pregnant. It's kind of a weird, I never understood how this device ever got put through, because when you realize it, what they're doing is they're taking a metal coil and they're putting into your tubes and creating scar tissue that prevents it from working. And it's just kind of, whoever thought of that and actually got people to invest in that company must have been a genius, because it just sounds awful. And it was. They no longer sell it because there were so many complications that are associated with that product. In my client's case, there were complications during the procedure. The doctor tried to put the tube in, lost track of the tube, lost track of the coil, and converted to a tubal ligation because he was not able to do the Essure implementation, which my client had consented to.
Sure.
That was in 2010. She has abdominal pain for 5 to 6 years, doesn't know what it's from, loses her health insurance because she lost her job, and she's Hispanic. She comes from a Hispanic family. Part of the family grew up in Rosarito, and so they did what a lot of people do, even non-Hispanics, and that's went down to Mexico for a low-cost doctor evaluation, and they took x-rays. The x-rays revealed that she had a piece of metal wire floating around somewhere in her abdomen. She had no clue. She consults with me. She tells me, hey, look, I don't know what this is from. I've only had these surgeries. I was supposed to have this E-share procedure, but the doctor told me that they couldn't do it. And so I had a tubal ligation instead. Well, I get the records, and sure enough, the records show that the doctor lost the wire. And I'm telling her, did he never tell you about that? No, I had no idea, she says. I bring in her husband. He was there. No, he never told us. I bring in her sister. She was there too the day of the surgery. No. Her mom. No, he never told us this. So I know right away it's going to be a he said, she said situation.
Right.
So I take the case, and literally everything went great. The doctor lied. He prepared a declaration that was inconsistent with what he said at his deposition. And so obviously, credibility is a big issue in a case like this. Everything went great, except, and I'm trying to think of why, because we ultimately did not prevail. The defense raised the statute of limitations, which for medical malpractice is 1 year. And in a case like this, if you know or have reason to suspect there was negligence back at the time of, even if it was 10 years ago, that 1 year statute of limitations starts to run from 2010. I was arguing that her 1 year statute of limitations started the moment she went to Mexico, and her doctors told her that she had a metal wire in her stomach.
Well, can I jump in and ask you, Andrew, because I thought that there was also a foreign object or foreign instrument exception to the statute of limitations for medical malpractice cases, like if a doctor leaves a scalpel inside of you. Does this not fall within that context, or?
It doesn't, because of the fact that it's a little bit different of a situation in that this device actually was intended to be left inside her. The whole idea is that they leave it in the tube.
I see.
And the doctor himself said, no, I lost track of it. I thought it was in the tube, but I wasn't sure. And I told her. And so his position was, I did tell her. And so when she started having pain, within 6 months of the procedure, she should have reasonably thought that it was from this retained device. And ultimately, that's what the jury believed, was God. That even if they didn't think the doctor told her, she should have reasonably suspected that her complaints were related to it. And what I learned was jury selection. There was a guy on that jury who I knew I didn't want him on the jury. In voir dire, he was an engineer. He was a real analytical guy. You could just tell he sat there with his arms crossed, looking at me. And for the life of me, when you're picking a jury, you only get so many challenges, and when you're out, you're out. And so there were some other really, really bad potential jurors on the jury panel that I got rid of. But the way I pick a jury is, the whole jury is watching you, and they're you challenge the jurors right in front of the whole jury panel. And I always, credibility is a big deal. I always want to project confidence and credibility. And so the last thing I want to be doing is challenging every single jury in the room.
Sure.
In my mind, I think it's better if you can say, hey, I'm happy with the jury. Let's go. Let's try this case. It looks like you get that going. And so I got to a point where even though I know I didn't like this guy, I thought that I had gotten rid of enough other bad ones and I had enough good people on the jury that at that point in time, I passed. And then it went to the defense lawyer who worked at Neil Diamond, by the way. And oftentimes what will happen when you pass early is the defense lawyer then starts to get nervous, and they're not ready to pass, so they strike somebody else. And now here you are, you're cool as a cucumber. I'm kind of using Neil Diamond's tricks against them. That was something that they taught me to do. And so I maybe I was getting a little too cute for it, but I passed, and then they passed, and so we had a jury. And sure enough, I talked to the bailiff after the case. That guy apparently was in charge of the whole thing. And the jury deliberated for 2 full days. Wow. Everybody thought they were just talking about how much money was going to be awarded. The bailiff, everybody thought that I'd won the case, and it was just a matter of how much. And we came back and they found, no, she should have known. And so clearly there was a lot of discord about that. But what I learned secondhand was that juror, because he was an older guy, people respected him because of his engineering background. He was able to really be an advocate for the defense and get people to come around to that opinion. And so I as I sit here today, I think had I gotten him off the jury, I would have won that case.
Wow.
I took a risk and I didn't. And that sometimes is how it goes.
It's so interesting to hear you talk about jury selection. It's something that as a young attorney, I probably had the, the confidence, but it wasn't warranted, just to think, oh, it doesn't matter who you try your case in front of. If you've got a winning case, you've got a winning case. And now I spend so much time, especially during quarantine, I've spent so much time listening to webinars and podcasts. There's one in particular hosted by Harry Plotkin, who is a jury consultant. I always get Harry and Barry mixed up, but I believe Harry is the jury consultant. And they talk. What's that?
Very different guys, those two.
Yes, very different guys. But Harry talks about just the importance of using a consultant for exactly the reason that you discussed. It's, the more people that you're getting rid of, and it looks like you're the one who's just in charge, taking notes, making decisions, you already have a jury who might be questioning your abilities as an attorney or just judging you in the actions that you're taking. Did you think to use a jury consultant on this case or have anyone with you, or was this one of those where you were confident and thought that it was better to do it alone?
Yeah. It's an economic consideration because Harry Plotkin is probably the number one guy in San Diego right now. Most people who want to use a jury consultant use him. But even if you don't use him and you use somebody like him, you're shelling out a pretty good chunk of change.
Of course.
At least another 10 grand in cost.
Yep.
And really that's your client's money, because you might be paying it out of pocket, but if there's a recovery, that money comes out of the client's recovery. And so at this point in the case, I felt it was a pretty straightforward medical malpractice case. And the reality is I knew that I needed to get rid of that guy. I just didn't do it.
Right.
And probably for a lot of the reason you did, I put what it looked like. I put the benefit of looking confident in front of the jury ahead of the importance of having a jury that I really thought was going to be the best for my client. And that's a mistake I won't make again, because I think the reality is that by the time the jury starts to deliberate, they don't even remember jury selection. They don't remember how many challenges you made or whether or not you were confident during that process or not.
Right.
They get in the room and they don't even care what you said. They get all the evidence in there. They get the exhibit binders and they start from scratch. And they're like, all right, let's figure out what happened. And everything you did for the past 3 weeks is almost meaningless. And what really matters is who are the people you put in there to make that decision. And so it's a mistake. I think I had 2 challenges left when I passed. And I could have knocked that guy off and somebody else if I wanted to. And in the future, I'll probably use almost every one of my challenges, unless I really feel good about the jury.
I'm just curious, what were some of your clients' chief complaints, like from having that instrument left in her? What were some of her damages, or was it just aches and pains type of situation? What made you choose that case in addition to the clear negligence that you saw on the doctor's part?
It's another interesting question. So the client comes and sees me. She'd had all these years of abdominal pain. Now we know what it's probably coming from. She's got this foreign device it's not in the tube, it's outside the tube. And so she sees a doctor and a doctor tells her she has to have it surgically removed. Now she's still uninsured. So she's got to go out of pocket now to have it taken out. So I think to myself, okay, it's a retained device case. She's claiming she was never told. Her whole family is going to support her. One of the things that she did during the years that she was having this pain was she went to this holistic provider called a magnet therapist. And what this person would do, would literally put magnets on her abdomen and then hold her hands on her head and close her eyes and maybe, chant or something, with the idea being that it would take away her pain. But obviously I'm thinking to myself, well, heck, if this woman suspects that she's got a metal foreign device in her abdomen, she's not letting somebody put magnets on her abdomen.
Right.
And so I thought that the evidence preponderated in favor that the doctor didn't tell her. And plus there were the out-of-pocket surgical costs that she would have to incur. And so I thought, I really didn't expect to try the case. I sent out the initial letters and filed the complaint. And I got a phone call from the adjuster for the insurance company that insured the doctor. And sure enough, it was a guy who I'd had countless beers with back when I was a defense lawyer. He's a good friend of mine who used to be my client. And he called me up and said, hey, this looks like a good case for you. Why don't you file it? My doctor's claiming that he told your client. But I tend to think that at some point we're going to be able to talk turkey about this case, which to a plaintiff lawyer is music to my ears. Like you want to resolve your cases, you want to get paid, you want to get your clients paid. Sure. So I do. 6 months later, this fellow retires, and what always happens in that situation like that, especially in the insurance world, is whoever takes over the file of somebody else, they're trying to look tough. And the last thing you want to do if you're working for an insurance company is to get into a new position and immediately say, hey, I think we should pay a bunch of money on these claims.
Right.
You want to do the exact opposite. So the person that took over, who I also respect, basically took a, no, screw you, this case should be tried perspective. And I never got a settlement offer.
Wow.
And so forced to try the case. And, it worked out for them and not me, but it is what it is.
Andrew, medical malpractice cases in particular, I find to be unique in the personal injury world for a number of reasons. But one being that oftentimes these insurance policies require the doctors to consent to any sort of settlement. I know that it's true in in a lot of dental malpractice cases, and in that field. To what extent do you find that to be true in cases that you work up in the medical malpractice? For doctors, and to what extent do you think it limits your ability to settle those type of cases?
Yeah, that's a great question. And it's something that anybody considering medical malpractice needs to understand. And that is that because what happens when a doctor settles a claim for in excess of $30,000, there is a legal requirement that the doctor or his insurance company report that settlement to the medical board. So it's kind of like an attorney reporting to the state bar that, hey, a client threatened to sue me and I paid him a bunch of money to go away. You don't want to do that. The last thing you want is the state bar breathing down your neck, demanding your file, looking to see if you did something wrong, and then maybe disciplining you in a way that could become a matter of public record. Doctors have the same concern. If a doctor settles a case and it's a big enough settlement that the medical board thinks there's something going on here, they might discipline the doctor, they might reprimand the doctor, but at the end of the day, even if they don't, it's a headache that nobody needs. And so anytime a doctor is being asked to pay more than $30,000, they're going to think twice about it because they don't want to report it to the medical board and have to deal with that gripe, especially if they think that they can win. And the reality is that everybody loves doctors, especially now in the era of COVID, where doctors and nurses are looked upon as heroes for putting themselves at risk for catching this virus by treating patients in the hospital setting. And so they get the benefit of the doubt. They tend to win a lot at trial. And so very frequently doctors, you might think you've got a good case. Heck, the defense lawyer and the insurance company might agree with you and say, hey, we think you've got a good case. We're going to recommend that the doctor consent so that we can go to mediation and try to settle this case. But the doctor might say no.
Right.
And if the doctor says no, then it doesn't matter if the defense lawyer thinks you're going to win or the insurance company thinks you're going to win. You're not going to get an offer and you're going to have to try the case.
Sure. And No, I'm sorry to interrupt, but just to give some of our listeners some context, normally if you're involved in a car accident, let's say, and you have $100,000 worth of insurance and you are sued for $50,000, your insurance company is going to pay for that, right? So if you, as the individual who caused the accident, are asked the question, are you okay settling for $50,000? You're going to say, sure. What's the difference? I don't have to pay anything out of pocket. And that player, that character is sort of taken out of the equation. Whereas in a medical malpractice case, what Andrew is saying is that for any injury over $30,000, any payment made by that insurance company more than $30,000, that doctor actually needs to give their consent. And when they give their consent, that gets reported to the board. You're able to look up that online. If anyone looks up their doctors before they actually are treated by doctors, you can see those dings on their record, so to speak. So it's very, very uncommon that a doctor will consent to that. And then you oftentimes are left in a situation exactly like the one that you were in here.
Yeah, and the funny thing is it can also happen the opposite way. I had a case last year where I represented an elderly woman who suffered a condition called giant cell arteritis. It's a vascular condition that, if not treated, can cause total blindness. And in this case, it did. She had these complaints. It was pretty classic for giant cell arteritis. Her primary care provider didn't do anything about it. She ends up going totally blind. She'll live the rest of her life in darkness. And we went to mediation. We settled with the ophthalmologist, and all that remained was the primary care doctor. The primary care doctor consents to settle the case. The insurance company says, thank you, doctor, for consenting, but we think that we should try this case. We think that we can defend it, and so we're not going to settle it. And so the doctors, at first, I guess, is thinking, okay, fine. That's be tough. Maybe the plaintiff lawyer will go away. Maybe he'll think that he got enough money already. Well, of course I don't. And so we go forward, and we went right up to the night before trial. And what the doctor had to do to get out of the case, because he's staring down the barrel of a 2-week trial. He has to leave his practice, sit in court for 2 weeks. Across the table from me and the 80-year-old blind lady that used to be his patient, and run the risk of being on the hook for what would have been a 7-figure verdict, considering all the future care needs that I was alleging she needed. And I had made a very reasonable settlement demand of him. In order to get his insurance company to pay, he had to go and hire his own personal lawyer out of his pocket, who then threatened to sue the insurance company for bad faith.
Wow.
If they didn't pay my settlement demand. And that's the only way the case resolved. And so I can think of no better example of just how hard it is and how crazy I must be to do this kind of work than that. A situation where you've got a doctor who's begging to get out of a case, wants to settle, wants to pay you your very reasonable demand, and he has to hire a lawyer to threaten to sue his own insurance company to do it. And that's what we're faced with. And I'm not the only one that's happened to. I remember I got the lawyer, his name is Alan Brubaker. He's a real good lawyer in town, been around forever. I got him a really nice bottle of scotch for his efforts on that case. But, I thought for sure we were going to try that case. And it wasn't until about 8:00 at night before the trial started that the case settled. And so It's tough.
Andrew, you talk a lot about the hurdles that you have to overcome in being a plaintiff's personal injury attorney who specializes in medical malpractice. Obviously, we've touched on some of those hurdles today, right? You have your non-economic damages cap. You have your sliding scale, how they pay attorneys on their fees. We've got doctors who often require giving consent before they will settle a case like this. To someone in my position who practiced in a state where we didn't have any of this sort of thing, what do you see as the future of this field in California? Because to me, this law enacted in 1975 that caps the damages at $250,000, it greatly it disfavors any people who are in a non-economic position, right? If you're not earning a high salary and you can't claim economics because of the same injury that a doctor does to you as they do to someone who's earning $1 million a year, a lawyer might not want to take that case because it's just not economically feasible for them. So it's a really shitty situation that they've put attorneys in, I think, in the state of California. But where do you see it going in the future?
Yeah, boy, I can tell you where I'd like to see it go. And that's with a total recall and pullback of all the legislation. How do we get there? So there was, I think in the 90s, there was an effort by consumer attorneys of San Diego, consumer attorneys of California, and other American Association for Justice, other consumer plaintiff organizations pushed to have the legislation overturned or modified, or new legislation put in its path. Those efforts failed because they were outfunded by the lobbyists for the insurance companies. About 5 years ago, maybe less, I want to say, there was a ballot measure.
Yeah, in 2014, it was up again.
There you go. And unfortunately, and so what that means is that we all have the opportunity to vote on that. And here's the problem with it. Until something bad happens to you or a loved one, and you realize that no lawyer will even take your case because they can't get more than $250 and it's going to cost too much and it's too hard and it's just not worth it, and you end up having to forego the claim. Or if you do, you're so limited in what you can get, it's unfair. And until that happens to you, number one, you probably don't even realize that law exists. But number two, you probably buy into the insurance company's argument that, hey, we've got to protect these doctors. Doctors are good people. They're trying to do the best. And oh man, these trial lawyers are just suing them for every, nonsense case that they can think of. And the doctors are all going to leave, and we're going to end up with horrible doctors if we let these lawyers just get their jackpot justice. So we need to limit those claims. That's if I had no experience with this, if I wasn't a lawyer, if I wasn't a victim of medical malpractice, I would hear that and say, yeah, that makes sense. I hear it, the McDonald's hot coffee case and all these ridiculous verdicts. We could talk about that too. It was not a ridiculous verdict, but But that's what people hear. And so what happened was, in California, that was put on the ballot, and people didn't vote for it.
Yeah.
Because they bought into the insurance company's arguments. And most recently, a very, very famous and wealthy trial lawyer named Nick Rowley was mounting his own effort to repeal MICRA again. And God only knows if he would have done it, but obviously COVID-19 happened and it blew it all up. And he probably sunk, probably $10 million of his own money into the efforts.
Yeah.
And he'll never, that's it. It's over. And at this point, now we're worried that Mitch McConnell or somebody at the state level is going to pass a qualified immunity legislation that protects medical providers during this time from any kind of claim, regardless of whether it's related to COVID or not. In other words, you could go in to get surgery on your right leg and the doctor could operate on the left leg instead. And not only that, do it improperly, negligently, and result in you losing your leg. But if that doctor can show that at the same time he was treating you, he was treating or involved in the care of COVID-related patients, he might have immunity from a lawsuit from you. So wow. You have no recourse against that doctor or his insurance company for losing your leg as the result of medical negligence. That's what Mitch McConnell wants to pass. And so, we went from a position of being really hopeful about Nick Rowley overturning MICRA to having our fingers crossed that we're not going to end up with some steroid version of MICRA at the national level.
Wow.
And so right now, I really just want to survive that and hope that we get what it is, because there will be legislation passed to provide some level of immunity to medical providers that are dealing with COVID. And I think it's probably warranted. Doctors in the nursing in the nursing industry, doctors and nurses in the emergency industry or the nursing home industry who are dealing with an influx of this disease should probably get some kind of relief because it's a crisis. And they shouldn't be second guessing how they treat patients for fear of lawsuits over a COVID situation. I get it. I'm not so dyed-in-the-wool plaintiff lawyer that I don't understand that argument.
Right.
But to apply it to non-COVID related care is gross overreaching, and all that really does, to bring it all home again, is serve the interests of the insurance companies who get to keep on collecting those premiums but not pay out on anything, and it's all profit for them.
Yeah. And you touched on Nick Rowley, who I saw on the listserv was making a push to have the at least to have this issue brought up on the ballot again, so that the voters could vote on it, and how he lost maybe $10 million just before all of this pandemic happened. It's interesting how in 2014, the biggest three insurance companies each threw something like $10 million at this issue to have it defeated. And how when you consider the enactment of the legislation back in 1975, like you touched on before, what so many people don't realize when you talk about benefiting the insurance companies with these issues, insurance companies are a business like most huge businesses. They take their premiums that their clients give them and they invest them in the stock market. And if the stock market is not doing well, as it was not doing in 1973 and 1974, two of the lowest years the stock market has ever had, insurance companies need to pass that cost over somehow. So the idea that there were these rising premiums due to more lawsuits is not completely factual. A lot of the X factors that you don't hear about are these are where these premiums are going. And I just think it's important that our listeners know about that. And that I also think it's important for people, whenever this issue gets brought up as a prop on the next, ballot in California, that you have an opportunity to research it the way that you should, and that it's presented to you in a fair way, so that when you vote on it, you know what you're voting for. You're not just voting for doctors' rights, and you're not just voting against, plaintiffs, personal injuries attorneys who are looking to make extra money. You're really, you're benefiting insurance companies, and you are doing a disservice to the people that are injured the most and who will be suffering the most at the hands of negligent doctors. It's just important for everyone listening in to understand that.
Yeah, and obviously I'm a plaintiff lawyer. It's not hard for me to take that position. The people that we need to turn around are the defense-oriented people or the medical provider-oriented people who are either medical providers themselves, and therefore they want those micro protections, or they've got loved ones who are medical providers and they want them protected. And, I saw Nick Rowley give an interview where he was asked, what would you say to those people? Because they're the ones that are voting against you. What would you say to them? And his response was great. And he said, I would ask them to check their integrity and to ask themselves to look in their own life for their favorite human, whether it's your mom, your spouse, your daughter, your son. Think of your favorite human and ask yourself, is his or her life worth $250,000? And when you break it down like that, it doesn't matter who you are, whether you're a doctor or a plaintiff lawyer. The answer is no. It's worth way more than $250,000. It's ridiculous to keep it limited like that. I think, unfortunately, the only way we're ever going to truly defeat MICRA is in the courts. And what I mean by that is, at some point, somebody's going to have to appeal a general damages award for $250. Because what happens is, you go to trial, the jury never hears about it. A jury might award you $20 million for your pain, suffering, and emotional distress. The judge says, thank you, jury, you're dismissed, sends them out the door, and then immediately enters an order after they leave, reducing the verdict for general damages to $250,000. And what it's going to take is a lawyer to appeal that judgment on the grounds that MICRA is unconstitutional as far as it has to go. And, we can go down the wormhole on that because we know where that leads, and we know who is appointing Supreme Court justices these days. And it's not someone who is a big fan of plaintiff lawyers and is very much a big fan of insurance companies and tort reform, so to speak. And the justices that have been appointed at the Supreme Court level are a reflection of that, unfortunately. And so I'm not optimistic that we are looking at the end of MICRA anytime soon, unfortunately.
So
I would love to be proven wrong. I would love to be proven wrong.
Yeah, I'd like for that as well, Andrew. I asked you about the future of medical malpractice in the state of California, but I want to turn now to what your thoughts are for the future of our jury trials here in this state and the nation, really. I know that you hosted a webinar earlier this year where you spoke with some of your guests about this. I believe you had BB Fell on as one who we've had on the podcast as well. And I know that you've talked about what this landscape might look like after this pandemic is over. Do you have any thoughts on it, or what do you think? Are we going to be able to try cases in front of juries again? Is it going to be what we're seeing on sports now with cardboard cutouts of fans in the jury booth and video Zooms, or where do you see this going?
I think we need to prepare ourselves for the very real possibility that we will never, and this sounds crazy to say it, but we will never try a case to a live jury again.
Wow.
And I hope I'm wrong about that, but for sure, no one's trying jury trials right now. In San Diego, they've basically said, don't plan on it for the rest of the year, maybe in 2021, maybe. But let's just think about it. What has to happen in order for you to try a case to a jury? You got to get enough people to respond to a jury summons on whatever given day that your trial starts. And you're not the only one starting trial that day. There could be 20 criminal trials starting across the street. They get preference. Mm-hmm. There could be 10 civil trials starting that day, and they start with the oldest. And so are enough people going to get a jury summons and say, sure, I'll take the bus with a bunch of strangers, go down to the public courthouse with a bunch of strangers and sit around and potentially get COVID and bring it home to my family just so I can miss work and get paid $3 a day to be a juror for a case. Nobody's doing that right now. And again, unless and until there's a safe and effective proven vaccine and or treatment, nobody's gonna do it. And so how long is that? I don't know. It's not unreasonable to say that it's several years away from being a situation where people feel like they're comfortable with the vaccine and comfortable going into public again. You can do your best to socially distance in the courtroom, but the reality is I don't want to bring, like, as a plaintiff lawyer, I don't want to bring people away from their families and their jobs, put them in a high-risk environment, make them wear a mask in court all day and stay 6 feet away from everybody else, which by the way, means that you're looking at a doubling in the length of time it takes to pick a jury because you can't call as many people up to choose from. And so it's going to take even longer now.
Yeah.
It just seems there's so many questions I have about how we can ever possibly do it again if people are still worried about the virus, I think that's going to be true for at least another year, that the question then becomes, okay, you can't just shut down the courts for another year. You've got to move these cases forward. So how do we do it? And I personally think that we're going to be looking at virtual juries much sooner than we otherwise would have been. And by the way, that was going to happen anyway.
Right.
I mean, we just look at the way technology is going on a micro scale. We were ultimately going to be in a position like this where we're doing everything remotely anyway. I mean, look at the sci-fi movies, Star Wars. You've got, Luke Skywalker showing up as a hologram on your hand. That's how you talk to him, or the Star Trek movies. But we're there. That's what look what we're doing right now.
Yeah.
And so I think that especially lawyers who are in law school now need to realize that mastering this technology and how to use it effectively in a trial situation is going to be a skill that they need to have. And I can't teach you that skill. The really famous trial lawyers that are doing webinars right now telling everybody how to pick juries and how to do closing arguments, it might be all obsolete already, because it might be a whole new type of trial that lawyers listening to this podcast end up doing, including you and me. And so what I do know is that means it's all about how you work up your case. And that means you got to videotape everything. And you should assume that when you take a deposition of a witness, that what you're doing is what the jury is going to see, that you're never going to call that person live, that the jury is going to see the deposition. And so when you wake up to that fact, you start to change how you take your depositions, you start to change how you ask your questions, how you strategize for it. And I think that's the future. I really do.
Yeah, it's a fun concept and topic to kind of talk about, the future of jury trials as we know it. I think that your take is very realistic. It's a very realistic possibility that while I hope it's not true, you might have tried the last jury trial to verdict in the city of San Diego, and I hope that that's not a title that you keep for a long time or forever. I've heard the talk of there being more bench trials. I know that I practice in federal court sometimes, and I know that federal courts have softly opened back up at this point in time. So it's a really interesting thing to think about. But one thing is for sure, that no matter where we go from here, things have certainly changed. That you need now more than ever to be comfortable with technology, to be able to do things like Zoom, be comfortable with Zoom, because that might be the direction that we're headed. Andrew, turning now to something a little bit brighter. Can you talk to us about something that you are excited about? Are there cases that you're working on right now that you're excited about? Do you have anything going on in your personal life that you would like to share? What's exciting and fun happening in your life?
So I think a lot of people, feel the same way. I've got two very young kids, a 1-year-old and a 3-year-old.
Oh, wow. Congratulations.
I see them every morning when they wake up. I put them to bed every night. A lot of times if I'm working from home, which I usually don't because there's no one else in my office, I come in because I can't get anything done with them home. But I'm obviously home more. I get to see them a lot more. So I'm excited that I am able to be with my kids more than I otherwise would be. If things were normal right now, I'd be, working weekends and I would have had several trials this year already since my last one, and that just takes time away. So I am excited about that. I'm excited about a future where you're no longer driving, 3 hours up to LA to take a deposition that lasts an hour and then driving 3 hours back in traffic. Those days are over. I don't have to do that anymore. I love that. That's great. I can spend 6 hours in the car. I can do something else with, whether it's work on my other cases or surf or do whatever else that I want to do. And so I think that's a huge benefit. We have some really interesting cases that we worked up right before the shutdown stopped, and we're trying to get them resolved. We have a mediation coming up on Monday on a case that's a really significant brain injury case where we represent a young lady who suffered an ischemic stroke that had a hemorrhagic conversion. In other words, the arteries dissected and she bled out in the brain, and she's got long-term permanent disability from it. And we just got some gangbusters testimony from the defendants that is really bad for them. And so we feel like we're in the driver's seat on that case, and we'll see what happens.
Wow.
On a lot of our cases, the defense lawyers and the insurance companies that they represent think that the COVID situation is a benefit to them, because without trial dates anytime soon, there's not a lot of leverage we have to push them into uncomfortable positions. And to the contrary, they can just sit back on their heels and say, hey, who knows when you're going to get your day in court. And so we'll just not offer you any money. We'll just sit back and we'll just wait for you to, come calling saying, hey, this case is taking too long. We'll take a reduced settlement. And that's what they think is going to happen. And so, they've got that wrong if they think that I'm going to do that. But I'm not saying that I'm not feeling the effects of that, or that my clients aren't either, especially elderly clients. I've got a case where I represent a 90-year-old woman who suffered a wrist fracture when her caregiver, the nursing home she was in, was understaffed. And so they had some pregnant caregiver who shouldn't even have been working go into her room to do a patient transfer. And because she was pregnant, of course, she couldn't do it. And she just yanked her by her wrist from her wheelchair into her bed and broke her wrist. Ooh. They're basically just ignoring me on that case because my client's 90. And they think, why would we ever offer to pay money on a case where the plaintiff is likely to die before she ever sees a trial?
Yeah.
And I hate to say that as bluntly, but that's what's happening right now. And so there's good stuff happening. There's bad stuff happening. I'm trying to focus on the good stuff. There's plenty of it. I'm lucky that I have plenty of that in my personal life, but there's some real challenges being a plaintiff lawyer in this environment.
Certainly. And, I just to jump back and talk about the webinar that you did, I know where you had BB Fell on, and you brought up this concept of, how are doctors going to be viewed right now in the public mindset, right? They are on the front lines. They're the ones who are there in the ICU treating patients with COVID, and how will juries sort of respond to that? And I think one of the answers that she or one of your other panelists gave was, I think you can view it negatively, or you can view it as a positive. If you are suing a doctor who has messed up, those people who are on the front lines, those doctors who are doing amazing things right now, use them as the comparison, right? Like, you can show the jury or get the jury to think about all of the amazing things doctors are doing right now, or nurses are doing right now, and juxtapose that with this nurse who yanked your 90-year-old client out of a wheelchair and broke her wrist, right? That juxtaposition, I think, will weigh heavily in a jury's mind and hopefully get them to side with you on a case like that. So, I'm with you. I hope that we make it through this sooner rather than later. And I hope that that this whole idea of delaying cases, as defense attorneys often use strategically, comes to an end at some point soon. So, I'm with you on that. Andrew, are there any books that you would recommend to our audience members? Anything that you've read that you would think is useful either in your field or, just for pleasure? Anything that you'd recommend?
Yeah. So regardless of whether you are going to be a defense lawyer or a plaintiff lawyer, and keep in mind, if you're in law school right now and you think you know what you're going to do, I'm Exhibit A to the concept that can change. You might think that you're going to be a defense lawyer and end up a plaintiff lawyer, or vice versa. And there's a lot of books out there telling you how to be a good defense lawyer. There's plenty of books telling you how to be a good plaintiff lawyer, how to do a closing argument, how to pick a jury, how to use demonstrative evidence at trial. And you could spend a lot of money and a lot of time reading them. I would recommend right now that if you are a law student or in your first 5 years of practicing, don't read any of them. Learn the basics, learn it by going out and doing, learn how to take a deposition, learn how to prepare a witness for a deposition, learn how to take an expert deposition. There's books out there that might help you, but there's no better education than doing it or watching somebody who's good at doing it, do it. And then talking to them about, hey, why did you ask this question? Or what were you going after there? That's the best way to do it. By and large, the books, they're just making money for the authors. And on top of all that, we don't, like I said before, I don't know that any of the concepts being taught in these books are going to be transferable anymore.
Wow.
So in other words, there's some really good books out there that tell you, David Ball on damages is a book that every plaintiff lawyer has read. I've got a copy on my coffee table in my office here, just sitting there. And I look at it before I go to trial just to refresh myself because it's got some great stuff in there about picking juries and what you think. But, does that apply to a Zoom jury or a virtual jury that's being done via video conferencing where they're not in the room with you? It's a totally different environment. And so I don't know that any of that stuff is transferable anymore. And so I'm not suggesting that those books don't have value. They do. I'm gonna, when I make this recommendation, I'm going to make it on the assumption that the audience here is mostly law students and they're doing plenty of reading otherwise. Read something for pleasure. There's a great book. Son of a gun. I can't remember the name of the author. The name of the book is Chaos. It's The Secret History of the CIA.
Oh my gosh. It's so funny it's just hilarious that you're mentioning this because I was listening to the Joe Rogan podcast this morning talking about, I think it's John O'Neill, I believe is the author.
Tom O'Neill.
Tom O'Neill. O'Neill is the author and the book is Chaos. And I've only listened to the podcast, but it's my first book that I'm going to go out and purchase after this because the concepts are absolutely crazy.
I read it in 4 days, cover to cover, and it is mind blowing, and it will totally change how you view that period of time and what happened. It doesn't really answer any questions, but it raises enough questions credibly to really blow your mind about what governments can and will do and have done. And it's the best. It's one of the best books I've ever read.
Wow!
And that was such a, for anyone who's got plenty of reading to do, a mandatory reading, whether it's for your studies or for a case. You want to read something that's going to suck you in and totally be an escape for you. And that book was it for me. So find a book. If that book's not your cup of tea, find a book like that. We lawyers do enough reading as it is. But I would recommend reading a book like that just to get your head out of the law for a little bit.
I'm kicking myself now as we near the end of our podcast for not asking that question earlier because it's just it's so serendipitous that you mentioned that when I was literally listening to the podcast on my way over to campus today. But just to give our viewers a quick background in the book, it's basically about the Charles Manson family and the murders that took place back in the 70s, I believe. But there's some significant research into this concept that the CIA may have had some role in it, and it talks about the use of LSD and drugs and mind manipulation. I have not read the book yet, but just hearing your endorsement on it after listening to this podcast for the last few hours today, I'm on board. So by the time we speak next, Andrew, I will have read this book and we'll have another conversation about it.
And just, there's no question. The CIA has acknowledged the program, MK Ultra. was a mind control program the CIA has acknowledged using LSD to implant memories and thoughts and erase memories and replace them with false ones in subjects. And this was tested on the public, and it implicates the Manson family. It implicates Jack Ruby and his role in killing Lee Harvey Oswald. And this book ties it together. It will blow your mind.
Oh my!
Blew my mind.
Wow. Well, like I said, that's going to be my first Kindle download following our podcast today. I was planning on downloading it anyway.
I will loan you the paperback if you're interested.
Oh, that sounds great. I would love that. That would be fantastic. Andrew, where can our guests find you if they want to get in contact with you? Number one, do you have a business account on Instagram? Are you on Facebook, Twitter, email, phone number? What would you like to provide for us?
Yeah, I have a website, chivinskilaw.com. I have a Facebook page. I've got a Twitter page. I don't have a law firm Instagram page, but I should have one. And all my information is on my website. I've got my phone number there, my email address, and I spend a lot of time on the phone every day talking to potential clients, other lawyers about cases, whether it's a potential case or they just want me to powwow with them about a case that they have. And I go back to when I needed help making the jump to being a plaintiff lawyer, people who were light years ahead of me did not hesitate to spend some time on the phone with me or going to lunch with me to talk and to lend me some assistance. They never hesitated. And so I've really tried my best to honor that by doing the same thing. So if anybody has a question about anything and wants to call or shoot an email, I will get back to them, and I would be, honored to talk and to help however I can.
Well, Andrew, I just want to thank you again for taking the time to be with us here today. Obviously, I know that you're extremely busy, so taking this time out of your day, I think we ran almost 2 hours today, almost an hour over our normal run time. We just had such an interesting conversation. You've been extremely, extremely interesting to talk to and to listen to. I think we didn't even mention some of the cases that you have had results for. So if our viewers want to go to chivinskilaw.com, you can see results as recent as the last few months where Andrew has settled cases for over $1 million for some of his clients, including medical malpractice cases, which obviously, as we've discussed, are some of the toughest cases to get settlements and verdicts on. If you have a serious personal injury case or a medical malpractice case, get in touch with Andrew. His number's on his website. Andrew, thank you again for coming on to the show today. To all of our reviewers out there, I am Michael Goldfaden. You can find me at goldfadenlaw.com. I just want to say thank you again for listening to the Bar Bites podcast and for watching the Bar Bites podcast. Thank you for signing on, and thank you for being here, Andrew.
Thanks. Really appreciated it.